Question 1. A signer presents a document with several blank spaces and asks for a notarization. The notary should A. Proceed with the notarization as long as the signature line is filled out. B. Instruct the signer to fill in the blanks with "not applicable" or "not applicable." C. Refuse to notarize until the signer fills in all blank spaces or lines through them. D. Fill in the blanks with the information the signer provides verbally. Answer: C. Refuse to notarize until the signer fills in all blank spaces or lines through them. A notary must refuse to notarize an incomplete document because blank spaces could be used for fraudulent purposes after the notarization is complete. The core concept here is protecting document integrity and preventing fraud, which is a primary duty of a notary. By requiring the signer to either complete the document or draw a line through the empty spaces, the notary ensures no information can be added later. Always remember, your seal on a document with blanks is a major risk, so make it a habit to scan every page for empty spaces before you begin. Question 2. A notary is asked to notarize a document for their spouse. The document is a simple travel consent letter for a minor child and does not provide any direct financial benefit to the notary. The notary should A. Proceed with the notarization since no direct financial benefit is involved. B. Refuse to notarize due to the direct familial relationship. C. Proceed only if another non-family member is also a party to the document. D. Ask their spouse to sign a waiver acknowledging the relationship. Answer: B. Refuse to notarize due to the direct familial relationship. A notary public must be an impartial witness, and notarizing for an immediate family member, such as a spouse, creates a clear conflict of interest, regardless of financial benefit. This rule is in place to maintain the integrity of the Notarial Act and ensure the notary has no personal stake in the transaction, which could call their impartiality into question. For example, even on a non-financial document, a future legal challenge could invalidate the notarization simply based on the spousal relationship. The best practice is to always avoid notarizing for immediate family to prevent any appearance of impropriety. Question 3. In a state that requires a notary journal, a signer refuses to provide a thumbprint for an entry related to a deed of trust. The notary should A. Note the refusal in the journal and proceed with the notarization. B. Refuse to proceed with the notarization. C. Proceed with the notarization but leave the thumbprint box blank. D. Offer to take a fingerprint instead of a thumbprint. Answer: B. Refuse to proceed with the notarization. If a thumbprint is required by state law for certain documents, like a deed of trust, it is a mandatory part of the Notarial Act, not an optional step. The thumbprint serves as a powerful biometric identifier to protect against fraud, and a signer's refusal to comply means the notary cannot fully meet the statutory requirements for the notarization. Completing the notarization without this required element would constitute official misconduct. Think of the required elements, ID, signature, oath, thumbprint, as a checklist where every box must be ticked before you can proceed. Question 4. The primary purpose of a jurat is to A. Certify the identity of the signer and that they acknowledged signing the document. B. Certify that the signer personally appeared, was identified, signed in the notary's presence, and was administered an oath or affirmation. C. Certify a copy of an original document. D. Certify that the signer is mentally competent to execute the document. Answer: B. Certify that the signer personally appeared, was identified, signed in the notary's presence, and was administered an oath or affirmation. The jurat is a notarial act that specifically certifies that the document was sworn to or affirmed as true by the signer in the notary's presence. Its key components, often remembered by the legal phrase, subscribed and sworn to before me, are the physical presence of the signer, the act of signing in front of the notary, and the administration of a verbal oath or affirmation. Unlike an acknowledgment, where the signing could have happened previously, a jurat requires the signing to be witnessed by the notary. A good way to remember is that jurat has the word jury in it, and just like a witness in court, the signer must swear to the truthfulness of their statement. Question 5. A signer presents a California driver's license that expired 15 days ago as proof of identity. A California notary may A. Not accept the license as it is expired. B. Accept the license as valid identification. C. Accept the license only if the signer is personally known to the notary. D. Accept the license only if it is for a non-real estate transaction. Answer: B. Accept the license as valid identification. California law specifically allows a notary to accept an identification card or driver's license issued by the California Department of Motor Vehicles that has expired, provided it was issued within the last 5 years. This is a unique provision and a common point of confusion, as many jurisdictions require ID to be current. The logic is that the photo and physical descriptors on a recently expired ID are still sufficient for positively identifying the bearer. Always be sure to know your specific state's rules on expired IDs, as this is one of the most frequently encountered and state-specific situations. Question 6. A notary public who is not an attorney is asked by a signer which notarial certificate to use on their document. The notary should A. Examine the document and select the certificate that seems most appropriate. B. Explain the difference between an acknowledgment and a jurat and let the signer choose. C. Refuse the notarization because the document is incomplete. D. Attach both an acknowledgment and a jurat certificate. Answer: B. Explain the difference between an acknowledgment and a jurat and let the signer choose. Choosing the type of notarial certificate for the signer constitutes the unauthorized practice of law, UPL, as it involves making a legal determination about the document's requirements. A notary's role is to perform the notarial act requested, not to provide legal advice. The correct action is to neutrally describe the available notarial acts, for example, explaining that an acknowledgment verifies identity and voluntary signing, while a jurat involves swearing the contents are true, and allow the signer to make the final decision. Remember, your job is to be the notary, not the lawyer. Describe the service, don't prescribe it. Question 7. A notary realizes after the fact that they forgot to have the signer sign the notary journal. The best course of action is to A. Leave the entry as is, since the notarization is already complete. B. Fill in the signature for the signer, noting that it was done after the fact. C. Make a note in the journal entry explaining why the signature is missing and that the notarization was completed. D. Mail the journal to the signer and ask them to sign and return it. Answer: C. Make a note in the journal entry explaining why the signature is missing and that the notarization was completed. While the journal signature is a critical component of a complete record, a simple mistake of forgetting it does not invalidate the already completed notarization. The best practice in this situation is to document the oversight honestly in the journal itself, which preserves the integrity of your record keeping and shows due diligence. Attempting to forge the signature or leaving a critical field blank without explanation could be viewed as misconduct, whereas noting the error demonstrates professionalism. The golden rule for journal errors is to never erase or cover them up. Simply line through the error with a single line, initial it, and add the correction or a note of explanation. Question 8. What is the fundamental difference between a notary bond and errors and omissions, E&O, insurance? A. A bond is required by the state, while E&O insurance is illegal for notaries. B. A bond protects the public from financial harm caused by the notary, while E&O insurance protects the notary. C. A bond protects the notary from lawsuits, while E&O insurance protects the public. D. Both serve the exact same purpose, but E&O provides higher coverage limits. Answer: B. A bond protects the public from financial harm caused by the notary, while E&O insurance protects the notary. This distinction is crucial for understanding a notary's liability. A surety bond, which is mandatory in most states, is a financial guarantee to the public. If a notary's error causes a financial loss to a client, the bonding company will pay the damages up to the bond amount, but will then seek reimbursement from the notary. Conversely, errors and omissions insurance is an optional policy that protects the notary's personal assets by covering legal fees and judgments arising from an unintentional mistake. Here's an easy way to remember: the bond is for them, the public, and E&O is for you. Question 9. A notary is presented with a document signed by an individual acting as an attorney-in-fact under a power of attorney, POA. The notary's certificate should name the person who A. Granted the power of attorney, the principal. B. Appeared in person before the notary, the attorney-in-fact. C. Is the beneficiary of the document. D. Drafted the power of attorney document. Answer: B. Appeared in person before the notary, the attorney-in-fact. A notary can only notarize the signature of a person who personally appears before them. In a power of attorney situation, the person physically present is the attorney-in-fact, the agent, not the principal who granted the power. Therefore, the notarial certificate must reflect who actually appeared. For example, personally appeared John Doe, as attorney-in-fact for Jane Smith. The notary is verifying the identity of the agent, John Doe, and witnessing his signature, not the principal's, Jane Smith. Always focus on who is standing in front of you, that is the person whose identity and signature you are notarizing. Question 10. A notary may not certify a copy of A. Power of attorney. B. Lease agreement. C. Birth certificate. D. Personal letter. Answer: C. Birth certificate. Notaries are generally prohibited from making certified copies of vital records like birth, death, or marriage certificates because a certified copy of such a document can only be issued by its official custodian, such as the county clerk or recorder's office. This is to prevent fraud and ensure the authenticity of these critical public records. While a notary can certify copies of other documents like a power of attorney, in many states, vital records are strictly off-limits. If a client needs a copy of a birth certificate, you must direct them to the appropriate government agency that holds the original record. Question 11. The date on a notarial certificate should be A. The date the document was originally created. B. The date the document was signed by the principal signer. C. The actual date and time the signer personally appeared before the notary. D. The date the document will become legally effective. Answer: C. The actual date and time the signer personally appeared before the notary. The date on the notarial certificate, also known as the venue and date line, records the moment the notarization actually occurred. It attests that on that specific day, the signer was physically present before the notary to be identified and perform the notarial act. Using any other date, such as the date the document was drafted or the date it was signed elsewhere, would be a false statement and is known as illegal backdating or post-dating. The date on your certificate must always reflect the when and where of your meeting with the signer, nothing else. Question 12. A signer's name on a document is Jonathan Q. Public, but their valid government-issued ID shows the name Jonathan Public. The notary should A. Refuse the notarization due to the name discrepancy. B. Proceed with the notarization, as the absence of a middle initial is generally considered an insignificant discrepancy. C. Have the signer sign the document exactly as their name appears on their ID. D. Require the signer to obtain a new ID that includes the middle initial. Answer: B. Proceed with the notarization, as the absence of a middle initial is generally considered an insignificant discrepancy. State notary laws generally allow for some discretion with minor name discrepancies, and the absence or presence of a middle name or initial is typically not considered a material difference, provided the first and last names match. The core principle is satisfactory evidence of identity. If the notary is confident they have identified the signer based on the ID presented, the notarization may proceed. For example, if the ID for Jonathan Public matches the person present and the document lists Jonathan Q. Public, the connection is clear. If you ever have a more significant discrepancy, however, it's safest to refuse or consult your state-specific guidelines. Question 13. A notary signing agent, NSA, is at a loan signing, and the borrower asks, "Is this a good interest rate?" The NSA's proper response is to A. Provide their opinion based on current market rates. B. State that they are not legally allowed to offer opinions or advice on the loan terms and should direct the question to the lender. C. Look up current rates on their phone to provide an objective answer. D. Advise the borrower not to sign if they are unsure about the rate. Answer. B. State that they are not legally allowed to offer opinions or advice on the loan terms and should direct the question to the lender. A notary signing agent's role is strictly to guide the borrower through the signing process and perform the necessary notarizations, not to interpret, explain, or advise on the loan's terms. Giving an opinion on the interest rate, even if well-intentioned, constitutes the unauthorized practice of law and oversteps the NSA's limited role. The correct and professional action is to immediately refer the borrower back to their loan officer or lender, who is qualified to discuss the legal and financial details of the loan. A simple rule for NSAs is, you can point to where information is located on the page, but you cannot explain what that information means for the borrower. Question 14. A credible witness used to identify a signer must A. Have known the signer for at least 1 year. B. Be personally known to the notary and swear or affirm to the identity of the signer. C. Be a family member of the signer. D. Possess 2 forms of government-issued identification. Answer. B. Be personally known to the notary and swear or affirm to the identity of the signer. A credible witness is a human form of identification used when a signer lacks acceptable ID. The fundamental requirement is that the witness must personally know the signer, and the notary must personally know the witness, thus creating a chain of trust. The witness then takes an oath, under penalty of perjury, that the person present is who they claim to be. Some states require 2 credible witnesses if the notary does not personally know them, but the core concept of the witness vouching for the signer's identity under oath is universal. Question 15. A notary's official seal or stamp is lost or stolen. The first thing the notary must do is A. Order a new seal immediately. B. Notify the commissioning authority, e.g., Secretary of State, in writing. C. Post a notice in a local newspaper. D. Wait to see if it turns up before taking any action. Answer. B. Notify the commissioning authority, e.g., Secretary of State, in writing. A notary's seal is a powerful tool that authenticates documents, and its loss poses a significant risk of fraud if it falls into the wrong hands. For this reason, state law requires the notary to immediately notify their commissioning authority, typically the Secretary of State, as soon as they discover the seal is missing. This official notification starts a legal record of the loss, protecting the notary from liability for any fraudulent notarizations performed with the stolen seal after that date. While ordering a new seal is also necessary, the official notification is the critical first step for legal and public protection. Question 16. A notary is called to a hospital to notarize a power of attorney for an elderly patient. The patient seems drowsy and occasionally confused, possibly due to medication. The notary should A. Refuse to notarize, as any sign of confusion automatically disqualifies the signer. B. Ask the attending nurse for an opinion on the patient's legal competency. C. Proceed with the notarization only if the patient can demonstrate awareness of the document's purpose during a moment of clarity. D. Complete the notarization but make a journal note documenting the patient's condition as a precaution. Answer. C. Proceed with the notarization only if the patient can demonstrate awareness of the document's purpose during a moment of clarity. The notary's responsibility is to determine that the signer is aware, alert, and acting willingly at the time of the notarization, not to make a medical diagnosis of long-term competency. A signer can be ill or medicated but still possess sufficient lucidity to understand the general purpose of the document they are signing. The notary should engage the signer in a brief, neutral conversation to gauge their understanding, for example, by asking, "Do you know what you are signing today?" If the signer can respond coherently and demonstrates comprehension, the notary may proceed. Remember, your duty is to assess awareness for this specific transaction, and if you have any doubt after trying to engage them, the safest course is to refuse the notarization. Question 17. A person who cannot physically write their name wishes to execute a document by making a mark, e.g., an X. The proper procedure generally requires A. The notary to write the person's name next to the mark and then notarize the notary's own signature. B. The person to make their mark, with one or more witnesses observing, and the notary writing the person's name near the mark. C. The person to make their mark, and the notary can proceed without any witnesses as long as the person has valid ID. D. Refusing the notarization, as a full signature is always required. Answer: B. The person to make their mark, with one or more witnesses observing, and the notary writing the person's name near the mark. Notary law provides a specific procedure, known as signature by mark, to accommodate individuals who are physically unable to sign their name. This process maintains the integrity of the signing by requiring the mark to be witnessed by one or two disinterested individuals, depending on state law, who then also sign the document as witnesses. The notary then writes the signer's name next to the mark and completes the notarial certificate, identifying the signer and noting the signature was made by mark. This ensures there are third-party observers to the act, preventing later claims that the mark was not made by the intended signer. Question 18. A notary public's commission is valid. A. In any state, as long as the notarization is for a federal document. B. Only within the geographical boundaries of the state or jurisdiction that granted the commission. C. In any state that has a reciprocity agreement with the notary's home state. D. Anywhere in the United States. Answer: B. Only within the geographical boundaries of the state or jurisdiction that granted the commission. A notary public's authority is strictly limited to the jurisdiction in which they are commissioned. For example, a California notary can only perform notarial acts while they are physically located within California. This concept is known as territorial jurisdiction. Even if the document is from another state or will be filed in another country, the notarial act itself must take place within the notary's commissioning state. Think of your commission as a license to practice within a specific state's borders only. Stepping outside those borders means you leave your notarial authority behind. Question 19. A notary's journal is requested by a member of the public who wants to see an entry for a transaction they were not a party to. The notary should A. Allow them to view the entire journal, as it is a public record. B. Provide a photocopy of the specific line item requested, redacting all other entries on the page. C. Refuse the request, as only a court order can compel the release of journal entries to the general public. D. Provide a certified copy of the requested line item entry. Answer: D. Provide a certified copy of the requested line item entry. While a notary's journal contains private information, it is also a public record that must be accessible under specific circumstances. A member of the public can request a copy of a single line item by submitting a written request that includes key details about the transaction. The notary's duty is to protect the privacy of other signers by providing a photostatic copy of only the requested entry, not the whole page. This balances the public's right to access information with the duty to safeguard the personal information of all other clients recorded in the journal. Question 20. The main purpose of administering an oath is to A. Verify the identity of the signer. B. Appeal to the signer's conscience and compel them to tell the truth under penalty of perjury. C. Confirm the signer has read and understood the document. D. Make the document legally binding. Answer: B. Appeal to the signer's conscience and compel them to tell the truth under penalty of perjury. Administering an oath or affirmation is a solemn verbal ceremony that forms the basis of a jurat. Its purpose is to have the signer formally declare that the statements in the document are true, with the understanding that a false oath constitutes the crime of perjury. The act of swearing or affirming impresses upon the signer the seriousness and legal significance of their statement. Whether they swear to a higher power, oath, or upon their personal honor, affirmation, the effect is the same, to bind the signer's conscience to the truthfulness of the document. Question 21. When is it appropriate for a notary to use a loose notarial certificate? A. Whenever the signer requests one for their convenience. B. When the original document does not have the required notarial wording or space to place the seal. C. It is never appropriate, the notarial wording must always be on the signed page. D. Only when pre-approved in writing by the Secretary of State's office. Answer: B. When the original document does not have the required notarial wording or space to place the seal. A loose certificate is a separate piece of paper containing the proper notarial wording and seal, which is used when the document itself lacks adequate space or the correct pre-printed certificate language. The notary completes this loose certificate and securely staples it to the signed document, making sure to add language that connects the two, such as, this certificate is attached to a page document, titled dot. This ensures the notarial act is properly documented without altering the original document. The key is to use it only out of necessity, not for convenience, and to ensure it cannot be detached and fraudulently reattached to a different document. Question 22. A notary who is also a real estate agent is handling a transaction in which they will earn a commission. The notary is asked to notarize the seller's signature on the grant deed. The notary should: A. Proceed with the notarization, as it is part of the service they are providing. B. Refuse to notarize because they have a direct financial interest in the transaction. C. Proceed, but waive the notary fee to avoid a conflict of interest. D. Ask a supervisor in their real estate office to notarize the document. Answer: B. Refuse to notarize because they have a direct financial interest in the transaction. A notary public is disqualified from performing a notarization if they are a party to the transaction or have a direct financial or beneficial interest in it. Earning a commission as the real estate agent in the sale creates such an interest, as the successful completion of the notarized deed is a condition for the notary to be paid. This situation compromises the notary's required impartiality. Even waiving the small notary fee does not eliminate the much larger financial interest of the commission, so the only proper course of action is to have a different, disinterested notary perform the act. Question 23. The term venue on a notarial certificate refers to: A. The state and county where the document will be filed. B. The state and county where the notary's commission is filed. C. The state and county where the notarization is taking place. D. The full address of the signing location. Answer: C. The state and county where the notarization is taking place. The venue is a mandatory element of every notarial certificate that establishes the geographical location where the notarial act occurred. It is typically written as state of county of ... This is critically important because it confirms that the notary was acting within their territorial jurisdiction at the moment of the notarization. For instance, a notary commissioned in Los Angeles County, California, who performs a notarization in San Diego County, California, must write State of California, County of San Diego, in the venue, reflecting where they physically were. Question 24. A notary in a state with a large Spanish-speaking population advertises their services using the term notario or notario público. This is A. Permissible, as it accurately translates Notary Public into Spanish. B. Prohibited in most states, as it can mislead consumers into believing the notary is an attorney. C. Permissible only if the notary is fluent in Spanish. D. Required if the notary primarily serves a Spanish-speaking community. Answer: B. Prohibited in most states, as it can mislead consumers into believing the notary is an attorney. In many Latin American countries, a notario público is a highly trained legal professional with duties similar to those of an attorney. In the United States, however, a notary public has a very limited, non-legal role. Using the term notario can therefore be dangerously misleading, causing individuals to believe they are receiving legal advice from a licensed attorney, which constitutes the unauthorized practice of law. To prevent this consumer fraud, most states have specific laws strictly forbidding or restricting the use of this term in advertising by non-attorney notaries. Question 25. An acknowledgment certificate proves that the signer A. Swore that the contents of the document are true and correct. B. Signed the document in the presence of the notary. C. Personally appeared before the notary, was identified, and stated that they willingly signed the document. D. Understands the legal consequences of the document they are signing. Answer: C. Personally appeared before the notary, was identified, and stated that they willingly signed the document. The core purpose of an acknowledgment is for a signer to formally declare, or acknowledge, to a notary that they executed a document for the purposes stated within it and that the signature is their own. Unlike a jurat, the document does not have to be signed in the notary's presence, it could have been signed days earlier. The key elements are the signer's personal appearance before the notary, positive identification by the notary, and the signer's verbal acknowledgement of their signature and voluntary act. Think of an acknowledgement as the signer saying, "Yes, that is my signature, and I meant to sign it."